We will analyze an example of having 6 questions. If that's the case, and make sure that you have a look at your syllabus as well. But we believe that if you have an exam where there are 6 questions and you should answer 3, our recommendation would be to revise these topics. But you should double check your exam papers as well as syllabus to make sure that it coincides. Usually joint tenancy, tenancy in common, severance, proprietary stoppable, easements, restrictive covenants and licenses, constructive trust and tilata should be enough to do the exam like this. But again, you should be able to find out what are the requirements for your particular exam and make sure that you adapt it accordingly. Joint tenancy. Usual form of co-ownership where the co-owners are members of the same family. So a married couple could have a joint tenancy. Co-owners are holding the property concurrently. Joint tenancies are treated as one complete entity. It doesn't mean that co-owners own the property 50-50, but they own the whole property together in undivided shares. One special feature of joint tenancy is right of survivorship. On the death of a joint tenant, his interest does not pass under the law of succession, but rather passes to the surviving tenant. Wherever there is a joint tenancy, it necessarily follows the 4 unities. So there must be the 4 unities present in order for there to be joint tenancy: unity of possession, unity of interest, unity of title, and unity of time. So in a problem question, if the legal issue is to decide whether or not the type of co-ownership given to you is joint tenancy or tenancy in common, that you need to describe the 4 unities. What are 4 unities? Does it apply to the facts of the case? Are there 4 unities on the facts given? So you need to consider those issues. Tenancy in common is very common today, common type of co-ownership. It is usual when the co-owners are in business relationship, but it can also be found in family. 2 or more co-owners of the freehold own it in the undivided shares. By undivided shares, the land is not divided by the income or benefit it is. Shares may be sold and moved on. Total shares may differ. The unity of possession is essential, while the other unities may be present but not essential. As in the scenario, if party dies, the shares are passed on successors. Whereas in tenancy, joint tenancy, if one party dies, their part of the property passes on the other tenant. After 1925, no more than 4 trustees could exist at tenancy in common. This was to mitigate the issues caused by a need of all legal owners to sign. So if in your problem question there are more than 4 or less, you need to mention that this is the law. 4 trustees should be there for tenancy in common. Important cases to read are Stack and Dowden, Lloyds Bank versus Rossett, and Eves versus Eves. We offer summaries of these cases, and it's freely available on SimpleStudying. You can have a look at those links after the session. Severance is also an important topic that you should revise. We have notes on it that gives you a summary of the majority of the important cases and principles that you need to know about severance. By severing a joint tenancy, it becomes a tenancy in common. For various reasons, this may be necessary for parties. For example, if a cohabiting couple break up and do not want to live together anymore, they may wish to sever a joint tenancy. So if owning the property together doesn't make sense anymore due to changing nature of the relationship, they may wish to sever the tenancy. There are various ways in which joint tenancy can be severed. Section 36, for example, the Law of Property Act 1925 allows any equitable joint tenant to give notice to the other joint tenant that they wish to sever the joint tenancy. It can be also by written notice. So if a letter was sent to the other joint tenants, an act operating on his own share, doing something that shows that the person is operating on his own share. For example, if one joint tenant sells their share to somebody, or 4 unities will no longer exist. That is why it will sever the joint tenancy. Another way to sever the joint tenancy is where joint tenants agree to sever by mutual agreement or by mutual conduct, the course of dealing. In a problem question, when you have to discuss severance, I suggest that you have a look at all these ways for severance and make sure that you apply the one that is the most relevant, or 2 or 3 that are the most relevant. So make sure that you discuss all possible ways of severance. So if section 36 applies, you should discuss that. But if there is any other ground as well that could apply, you should discuss that as well. So how do you answer a problem question on co-ownership? Discuss if it is a joint tenancy or tenancy in common. Analyze the 4 unities and justify your answer. Discuss if there is a valid severance and sum up the main points and conclude. Example problem question that we will discuss today is the following. John and Emily decide to move to the countryside. They purchase a freehold to a house which they hold as joint tenants. However, as time goes by, Emily misses the city and wants to move back, but John doesn't want to. Emily writes and posts a letter to John saying that she wants to move out of the house and buy a flat in the city for herself. On the day the letter arrives, the house, Emily picks it up from the letterbox, but then forgets to pass it on for John to read. So did the severance take place? That is the main issue here. This is just an extract from a problem question that we have on the website. So have a look at it. Here, no issues arises as to whether the co-ownership is joint tenancy or tenancy in common. The issue is if joint tenancy is effectively severed. Apply it to section 30. Apply section 36, which is a possible ground for you to establish the severance. Section 36 permits any joint tenant to give his notice in writing to all other joint tenants. This converts the joint tenancy into a tenancy in common. It is entirely unilateral. It does not need agreement from the other parties. And the severance must be made in writing. For severance under this heading to be effective, the notice must be received by all other joint tenants or be deemed to have been received. It must use the wording appropriate to effect a severance, and it must express a desire to sever the joint tenancy immediately. If these requirements are satisfied, then it could be effective severance. Also, applicable law cases should be discussed. Berkeley Road, you can have a look at Kinch versus Bollard as well, and Quigley, Masterson. As Henderson J. pointed out in this case, it is important to remember at this point that the giving of a notice of severance is essentially a unilateral act, which does not depend in any way on the agreement of the recipient. So John did not need to agree to severance. As long as the notice was communicated, it should be effective. But there are other cases that you should also discuss and other considerations you need to analyze. And you should make sure that you mention all the relevant laws and discuss all relevant points that should be mentioned. Here it seems that the letter clearly expressed the intention to sever the joint tenancy and it was delivered at the right address. Applying Kinch versus Bollard, severance should be effective because it is not required that the recipient reads the letter. It was as per Kinch versus Bollard, even if the recipient does not read the letter, the severance should take place if it was delivered at the right address. Therefore, in this on the facts that we read, severance should be effective. Another topic that you should be revising is proprietary support. It often comes up in problem questions. You can read our notes on the website, and we will revise quickly now the proprietary stoppable as well. Proprietary stoppable comes into play when a person acts to their detriment on reliance of an expectation that they will receive an interest in land from a landowner. It prevents a person from insisting on his strict legal rights, whether arising under a contract or on his title deeds or by statute, when it would be inequitable for him to do so, having regard to the dealings which have taken place between the parties. Proprietary estoppel serves to mitigate the harshness of common law. Similar to promissory estoppel, if there was a promise given to the person and on reliance on that promise, the person suffered detriment, then proprietary estoppel should be used to mitigate the harshness of common law rules. Therefore, there are 3 stages. Defendant made representation or assurance giving rise to claimant's expectation. Then claimant relied on that assurance and claimant acted to his detriment. There are cases like Gillett versus Holt and Inwards versus Baker that you should know about proprietary estoppel. I suggest that you have a look at those cases after the revision session. Easements is also an important topic for you to have a look. An easement is where one landowner allows the use of their land to another landowner for the benefit of the other landowner. The key case here, which established the requirements for easements, is Ellenborough Park. You need to cite this case as a starting point in a problem question when you're applying law on easements. There must be a dominant and a serving tenement. The easement must accommodate the dominant land. The easement must be owned or occupied by different people. Easement must be capable of forming subject matter of the grant. The last requirement has subsections as well. What kind of circumstances can the easement be capable of forming subject matter of the grant? And you need to make sure that you discuss those legal considerations as well. Restrictive covenants is also an important topic. It often comes up mixed with easements in the same problem question. So if you're revising easements, I suggest you also revise restrictive covenants and licenses. Restrictive covenant is a promise made in a deed between landowners where one party will restrict the use of its land in a way which will benefit the other party. So if in case of easements, they allow the land to be used, here they restrict. So it's a restrictive, that's why it's called restrictive covenant. For instance, the area where you live may have a policy not to change the outside decoration. If the house where you live in has some kind of restriction that you cannot do certain acts on the property, then it could be a restrictive covenant. Tolata is also another topic. This legislation is a very important legislation for land registration, and you should be able to know what are the main sections. Section 13 to 15 is usually very common for land law exams to ask about these sections. So make sure that you revise it. If the trustees cannot agree with each other and are in dispute with their beneficiaries in relation to the property, Section 14 allows any of the parties to bring an action to the court to decide. Where a dispute of a trust of land has arisen, Section 13 to 15 of Tolata provides a procedure for the court to settle the dispute. These provisions replaced Section 30 LPA. So what is Section 14? Permits anyone with an interest in the property to apply to the court for an order. The case brought under Section 14 are likely to fall under one of these categories: disputes regarding the size of co-ownership interests, disputes regarding occupation of the trust land, authorizing transactions without requisite consent, disputes as to whether co-owned land should be sold, and Section 15. The provision sets out the factors that the court should take into consideration when making an order settling a dispute brought before it under Section 14. So you need to first start with the Section 14, say that this permits anyone to bring with an interest in the property to apply for a court order, and then Section 15, which sets out the considerations for the court that they need to take into account when they are settling a dispute. These factors are intentions of the persons who created the trust. For example, if the trust was created for matrimonial home, then if the purpose of the trust no longer exists, that will be an important factor for the court to take into consideration. If the couple got divorced, the purpose of the creation of the trust for matrimonial home would no longer exist. Purposes of the property which is subject to the trust: for what purpose was the property purchased? Welfare of a minor, if there are any kids, their interests will be taken into consideration, and interest of any secured creditors. If there are any mortgages over the property, that would be an important factor to consider. I suggest you have a look at Bank of Ireland home mortgages versus Bell, as well as First National Bank versus Achampong. Those are very important cases about later, and we have the summary of it on SimpleStudying available. Recommended questions to practice with. You should practice with our example questions and answers. Read the question, draft the answers yourself without reading our answers, and then compare our answers to your answers. In addition to that, I suggest you have a look at your past exam papers and answer the questions from there as well. And if you need help answering those practice questions, I highly recommend you to have a look at our tutoring services. We have exam preparation packages where most of the students get those exam preparation packages to answer the practice questions with the tutor. When you have already answered the past exam papers and you have practice questions already studied and answered, you should be able to answer your upcoming exam as well very easily. Yeah, and anything else? It's highly recommended to have few tutorials with us to get tailored feedback as well on how to improve your answers. The tutor will be able to meet with you on Zoom, have a few hours with you, depending on how many tutoring sessions you get, and work with you to improve your legal writing skills. At SimpleStudying, we have summarized the important information for you. We are, our team of content creators are top students and graduates who have all gotten high grades in their relevant law examinations, and our materials focuses specifically on how to get high grades in the simplest way possible. If our resources are not enough, we have tutoring services. We have already helped thousands of law students get high grades. Our regular students usually get a first class after working with us the entire year very hard, as you can see on our reviews. If you want to be our next student to get high grades, please join SimpleStudying now. Thank you very much for your time.